Okay.
Okay, good afternoon, everybody. It's 12:06. We're learning our way around this new state bar rule, and hopefully next time we'll be right on the minute. We had one public comment, and are there any other public comments? Anybody?
Nobody has their hand raised.
Oh, there is one person that has.
Just a second, Dawn, do you want me to do the Zoom housekeeping stuff or not?
Oh yeah, should we do all the housekeeping and roll call and then public comments, Patience?
You know, I'm just looking at the agenda and following the agenda, so it doesn't really matter. I don't believe it would make sense to do call to order. We've done the call to order already. Let's do the roll call and then we'll do the
okay. So Kim, why don't you do housekeeping and then I'll do roll call.
Okay. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Rules Committee meeting. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the meeting. Friendly reminder that that this is a video conference meeting, and please be aware of the surroundings behind you. All Legal Services Trust Fund Commission meetings and committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen and then select enable transcript. Thank you.
Okay, we have a public comment, is that right? Somebody has a hand raised somewhere.
Yeah, there's one hand raised. I'll allow them to talk.
Good morning, good afternoon.
Good morning. My name is Lindsay Nacco, and I'm the Executive Director of the Impact Fund. Can everyone hear me okay?
Yes.
Okay, thank you so much. I appreciate the opportunity to comment on the proposed rule regarding pass-through funds, now known as excluded expenditures. As a state bar funded support center that has a significant amount of pass-through funds, I am very grateful for the clarity in this and the time that the Rules Committee has spent to define excluded expenditures. We did have one question regarding the proposed revision to State Bar Rule 3.680 Cap E3A regarding in-kind and donated services. So our organization receives donations of AdWords services from Google, and it is something that we consider to be an excluded expenditure because we don't receive the monetary value of those. It is not money that we would otherwise spend except for the donation from the company. So we had a question about the use of the term volunteer under the donation of in-kind and donated services, and whether it would be possible to have that the definition of in-kind and donated services clarified to include contributed services provided by a volunteer or a company or another source that is recognized and recorded at the fair market value as verified by our audited financial statements.
Okay, and we also got that comment in writing by email earlier today, I guess. So thank you. Does anybody have any response or thoughts about that? Lindsay, is there anything else you want to say?
No, happy to answer any questions that anyone may have. And I appreciate the Rules Committee's consideration.
Okay, Heidi.
Patience, can I make a suggestions before if members or staff have that we should do roll call before we?
Sure.
Alikani?
Present.
Al-Sarraf?
Present.
Blakemore?
Present.
Campbell? Connolly?
Here.
Galkin?
Here.
Danville?
Here.
Milrod?
There.
We have quorum, and then I see our liaisons are here too, and State Bar staff, so I'll turn it back to you. Sorry about that.
Okay, Heidi.
I just wanted to say that we do have a proposal to address the impact funds concern that came in. And so I do plan to address that during the presentation.
Okay, all right. Is there anybody else who wants to make public comment? Okay, closing public comment. Oh, sorry, Selena.
It's fine. Just the liaison comment that Lindsay's question was pretty common from what I heard from others too, is just they probably wanted a little bit more clarity when this is rolled out, similar to the webinar that was earlier this week explaining rules revision changes. Everyone kind of wants to know, like, how does this impact what I've been doing for 15 years? And so having more specific examples, which don't have to be part of the rules, but part of the rollout, would be helpful.
And there's another comment. There's another hand raised in the public.
Thanks.
Hi, this is,
Brown.
yeah,
Yes,
this is Ariel Brown with Immigrant Legal Resource Center. We also just wanted to share that, you know, the Immigrant Legal Resource Center has been a support center since our inception in 1979, 45 years ago. And we re-grant to many legal service providers as a way to facilitate the funding of legal service providers and the obtainment of legal status, family reunification, educational, health, and employment options for our immigrant communities. And we work with many foundations who want to support client communities, but do not necessarily have the capacity to become subject matter experts. So they rely on organizations like us to select the grantees and administer the funds. And so we're concerned that the language regarding required subgrants will not cover some of these subgrants. And you know, we're raising this issue because this would affect our ability to assist philanthropic goals, as well as build the capacity of the field and help low-income Californians. So we would ask that the State Bar consider rewording that fourth category to include all subgrants as excluded expenses. We're also concerned about the requirement for support centers to provide documentation of all their subgrants. We re-grant more than $10 million to nonprofits around the country, and so such a reporting requirement would be very burdensome for us.
so you are referring to which section? Are you looking at attachment A?
Yes, here, let me see if I can pull up the exact site for you. Let's see, so it's the section, I actually still don't have the site, but it has to do with the different types of things that would, that should be excluded, in-kind / donated services, unrealized loss, direct assistance funds, fiscal sponsorship funds, and then required subgrants. And so the required subgrants, that wording is the one that we are a little concerned about right now. And I suppose you can take me off the audio and I can follow up with the exact site if that would be helpful.
What would be super helpful is some proposed language.
Sure.
Some
Yeah, that's
red line
something we can also follow up.
language. Okay, so you're gonna go off audio and I'm gonna call on Erica right now.
Thanks, Patience. Actually, this is a question for Ariel. So in your situation, is it not that, I guess I'm a little confused as to what kind of grant you think you would not be covered under there?
So I guess there are situations where we choose to subgrant, but we're not sure it fits under what the current proposed language considers required. And so this would mean that we would, you know, either subgrant less, or this might affect our ability to meet the definition, right, of primary support.
And are these, the subgrants would not otherwise be like a qualified expenditure? Is that the concern?
Yes, that's the concern.
Okay. Thank you.
Right. Errol, do you have anything you want to add right now?
No, not right now. Thank you.
Thanks. Thank you. Selena.
I know we'll get to the discussion of this item later, but just flagging that what I recall when we talked about this over the past few years is that some organizations are given funds and they are told distribute this to these number of organizations at this amount. And some other organizations are given funds and it's required that they subgrant, but there's more discretion in who they choose. And so I think it's that issue of required and how much guidance are they getting from the foundation or even from a government entity to do the regranting. That's the piece that organizations just want to know that if the current practice, if that's fine, or if they need to make major changes.
Is this something, Selena, in your understanding, that would logically fall into an FAQs document? Or is this something that needs to be addressed in the rule itself?
I think it could be, it's almost like the definition of required may need a little bit of clarification in the rules, but then the FAQ would answer it. Because it's a supporting documentation piece is, verifying the restrictions and the amount of funds for direct assistance funds. I think we'd want to hear from ILRC, and so many organizations do subgrant to find out what do they get from the foundation or government entity that gives them the money, so that they could perhaps attach the MOU with the government or the grant agreement and not have to do additional work, like attaching every single MOU with every single subgrantee.
Let's defer the rest of this conversation to the agenda item. Duan, did you want to add something?
Yeah, I was just gonna say, I think we take the public comments, but my suggestion is we have an agenda item, we have a staff presentation, a working group presentation. It makes, to me, more sense to have that discussion at that time.
Perfect. Okay, so closing public comment. Do I have a motion to approve the minutes?
I can make the motion.
Thanks.
Catherine will second.
I'll do roll call. Alakani,
Yes.
Al-Saraf,
I mean, you're muted.
I said yes. Can you guys hear me?
and my roll call, I have Fight Master that I know she's off so I'm gonna skip over that. And Kim, could you give me another roll call sheet? Blakemore,
Yes.
Campbell, Connolly,
Yes.
Galkin,
Yes.
Stanville,
Yes.
Milrod.
Yes.
Motion passes.
So let's go to the main event today. Heidi, are you presenting on this? So the floor is yours.
Thank you. I'm actually co-presenting today with Crystal Bunding and Jonathan Sandville. So we will be presenting together. Let me share my screen. Okay, so good afternoon, everybody. Today we will be talking about the excluded funds, formerly known as pass-through funds, exchange funds, and county expenditures. So today we want to start though with discussing our fiscal codification strategy, because we are intending, or our plan is to deviate a little bit from the normal codification process, and I'll go over the why on that in just a moment. And then we'll go through each of the topics and the recommendations, and then we can have discussion, and then we do have a proposed resolution that we can review together. So starting with the fiscal codification process and strategy. So the normal process for codification topics is it comes to the rules, and the working group works on it, presents a recommendation to the rules committee. Then once that's approved, it goes to the trust fund commission to request it go out for public comment. And then once it comes back to public comment, the legal service trust fund commission makes any changes and then approves and then sends it to the board of trustees for final approval. What has happened for the fiscal codification topics, because we're doing it in a sort of one topic at a time, we have found that this process is not as effective for the codification topic because there's so many intermingled pieces. So for example, you'll see today, we've already sent out a rule for public comment about the state bar grants, but in defining the rule or rewriting the rule for excluded funds, we felt it made sense to go back to that same rule and expand it to, because that's naturally where the excluded funds would get addressed. And so we would like to propose that we, instead of going from the Rules Committee to Legal Service Trust Fund to out for public comment, we get approval at the Rules Committee in a step basis. And then once the whole rule is packaged and all the different pieces have been addressed, then we would send it out for to the Legal Service Trust Fund Committee to request public comment. So just to give you a little context of what these are, the various individual rules that we have presented and sort of the and they're where they are and what rule they touch. So if you'll notice here, the state bar grant deductions, which was sent out for public comment, is in 3.68. The audit finding rule is in 3.68. It's not been sent out for public comment. And then the funding deductions in 3.683, and then so on and so forth. And then the rules that we are going to be talking about today, as well as the rules that we'll be talking about at the May meeting, also hit that 3.68 rule. So we want to wait and not keep sending it out in pieces and instead package it all together. So if anybody, has and objects to that strategy, let the working group know. But we feel like for this topic in particular, it doesn't make sense to go out for public comment with the same rule multiple times. So instead, wait till we've built all the pieces of it. So that's our strategy. And so if anybody objects on the rule committee level, please do let us know. All right. So starting with excluded funds or pass-through funds, which are what we were discussing with the public comments. In terms of excluded and pass-through funds, the current practice for excluded funds is starting in 2019, a new section was added to the IOLTA and EAF application to capture pass-through and fiscal sponsorship expenditures. Prior to this, the staff identified these expenditures informally and they made adjustments accordingly. These expenditures are excluded from the calculation for primary purpose determination, and as well as the qualified expenditure calculation for QLSPs, and so that they won't impact their allocation amount. So they serve two purposes. In the current application, pass-through funds are identified as funds that are passed through from an applicant to another organization for which the applicant has no involvement, oversight, or engagement in the execution of the funded work, i.e., for example, program simply forwards payment to another organization, but is not involved in decision-making and does not have oversight responsibilities or involvement, or its involvement is limited to selecting a sub-grantee, but the program does not participate in the decision-making or oversight beyond that. So that's the definition now. There was a prior working group that did take a look at pass-through funds, and it went through the Rules Committee. However, it never went out for public comment. And so in keeping with the full look at the fiscal codification, this working group reviewed that working group's recommendation and decided it wanted to take a second look at this topic. And so when we got together as a working group, the considerations for this particular topic were that the prior recommendations did not align, that the prior recommendations from that former working group did not align with our holistic fiscal approach that we're currently taking as a working group. It did not clarify it didn't have enough clarity for the purpose of the pass-through funds. The current definition wasn't inclusive, or the current definition of pass-through funds is not inclusive, and it's sometimes confused with the pass-through definition that's used in accounting. And so that overlap of terms where it means something in accounting terms versus the state bar application terms for some grantees has resulted in inconsistent interpretations from grantees about what to report as pass-through funds or exchange funds. And in some instances, grantees are actually putting money in the pass-through fund because they interpret it under the definition of accounting terms, and thereby reducing their grant amounts because it would be otherwise a qualifying activity, but because of the reading of that pass-through term, they've excluded it from their qualified expenditures. And then unlike exchange funds where grantees do upload the contracts related to the funds, there's no validation of what organizations are taking off of the top. And so grantees just put the amount in there and we have no way to validate that that amount is in fact tied to a particular grant or activity. Sometimes it shows up in the audit and you can tie it to, but most times it doesn't. So there is no validation for this exclusion of funds in the current system. And so I will turn it over to Jonathan at this point to present on the working group's recommendations related to this topic.
Thank you, Heidi. So given the aforementioned considerations, the working group is making the following recommendations. The first being to replace the term pass-through with excluded funds. The second being to provide clear definitions of the type of funds that should be excluded from the applicant's corporate expenditures. The third being require applicants to provide supportive documentation to validate any excluded funds reported. And the last one is to require applicants to track and deduct administrative expenses related to the oversight and distribution of excluded funds must as non-qualifying activities.
Okay, sorry, there's a typo in there, Jonathan.
Yeah.
Sorry. So we did go out for community feedback. We had a grantee feedback session that OA and I staff led on January 31st, where we presented the initial recommendations of the working group. And at that meeting, there was no clear opposition to the proposed definitions and the clarification that was being recommended for this topic. There were questions about the nature of what would be excluded and the limits around that, as well as the tracking of administrative fees related to the distribution of these excluded funds. And then in March, we sent out the memo on the proposed rule to LAC and requested feedback from the community via LAC. And the feedback that came in was that LAC generally supports the greater clarity in defining what counts as qualified expenditures and what is excluded. They reported that the new categories for excluded funds will lead to equity between programs when determining what is included in the primary purpose calculation. And then they also, as Selena mentioned earlier, suggested that a frequently asked questions document be developed to help grantees understand the excluded funds and how to put it into place. So this is the language of the proposed rule as recommended by the working group. For the question that the impact fund originally asked about around in-kind donations, we've made the following edits, and we'd like to propose that be the way to resolve the impact fund question, because the purpose of deducting in-kind donated services and unrealized loss, these are non-cash items that show up on audited financial statements. And so there isn't a change in the procedure around those. We are just simply trying to codify that. So based after having conversations with the impact fund and understanding what they are what they're recognizing on their financial statements and others, we've modified the language a little bit. So I've added the purple is add and the red strikeout is to eliminate from the prior definition. So it would update the in-kind / donated goods and services would read contributed goods and services recognized and recorded at the fair market value as verified by the audited financial statement. And so that is my proposed suggestion for dealing with that issue, because I think that gives enough leeway. The intention is non-cash, in-kind, and donated services would automatically be excluded because they're not. There's no cash value. And then the rest of this definitions where I think the focus is exclusively allowing 3 areas of excluded funds. 1, direct assistance funds. So those are restricted funds. So that means that the the contract between the person or the entity providing the funding to the other entity requires them to distribute these funds. This is not something that's available for general use, and they couldn't provide other qualified legal services activities with this funds or anything else. These are not these are restricted funds that are only for the purpose of direct assistance funds. Same thing with fiscal sponsorships. This is where they have a fiscal sponsorship agreement, and that they are only providing these fiscal sponsorship funds that are coming in for the purpose of giving it to the entity who is not able to receive the funds directly. And the last being required subgrants. Again, this is not an organization who is choosing to subgrant. This is an organization who is receiving funds for this specific purpose of subgranting it out. And so that would be excluded funds. If they are making a choice to distribute their own funds that they could choose to use in any direction that they see fit, we saw that as a service that should count towards primary purpose on the working group. And so the only thing that gets excluded off the top from your primary purpose calculation and or your qualified legal services are these required, these contracts that establish a restricted fund that then has to serve a restricted purpose. And so that we are asking for supporting documentation. So each of these transactions should have a contract associated with them. So we're just asking for the contract to be included in the application, which is similar to how exchange funds works now. And then because this work, the work of distributing these funds is not seen as a qualifying activity, they would have to track the administrative expenditures related to distributing these funds, and that would be deducted as a non-qualifying activity. Yes, Catherine.
Thanks so much. And I do appreciate all the clarity that we're trying to derive from the rule. I think that'll be very helpful. And just, I guess I just have a couple of questions about some of the last three that you highlighted would be maybe questions. So D refers to fiscal sponsorship funds. At least in my experience, like, first of all, I don't know why it says unincorporated entity, because it could also go to a entity that was incorporated. So I'm not sure the reason for the distinction. And then the second is sometimes the fiscal sponsorship might include a direct amount to the qualified legal services program, as well as some other funds that were going to the entity, right? So you're both a fiscal sponsor and a direct recipient. So curious if those are handled differently, meaning you count the portion that went to the legal services organization and you exclude, for example, the portion that in the prior thinking would have been like a pass-through, it's going to someone else. And then the administrative part I'm interested in, because I'm assuming administrative, like in the one example I can think of, where we received funds, we did direct work. A portion of our direct work was ensuring the quality of the materials the incorporated CBO was providing. So I'm assuming this is not intended to exclude as an administrative cost, the supervision cost of that, but instead things like the checks or whatever you were supposed to be sending to the entity it's the CBO. So those are kind of the questions about the fiscal sponsorship portion.
So the fiscal sponsorship portion, so in answer to your question as to where the QLSP gets to keep part of it and sends part of it out, the excluded part would only be the part sent out to the fiscal sponsor agency. So if you're using the rest of the money to provide some other type of service that's qualifying, then you get to count that. It's only the portion that you're sending back out to the fiscal sponsor agency, or at least that's the intention. As to the term unincorporated versus incorporated, I did a definition search for fiscal sponsorship. And so this was like the most common definition. So that's why, but I think we could certainly make it an entity as opposed to and take out the incorporated versus unincorporated. I think that would be an easy shift to address that, and that wouldn't be make a substantive difference, you know, in terms of the intent behind the rule.
That'd be great, because I think sometimes funders like look at a CBO that's incorporated, but say you don't have sufficient fiscal management in place or a history of receiving grants, and therefore they want that organization to have a fiscal sponsor. So that would be great. And then for the administrative cost, it does, I just want to make sure I understand, like it says you can't your, I don't know, your costs associated with administering it, like just clarity about what you're intending for that.
So let's say you've got a rental assistance program and you've got staff, and the only thing they do is, you know, process rental assistance applications or questions or whatever, you know, so like that to me is an administrative task, you know, of distributing that. That's not a legal service task. So I think that, or if you are a grantee that administers, sub grants, you know, sort of the fiscal oversight of the administrative oversight, the and the activities related to, you know, giving away that money is what we're more interested in deducting as a non-qualifying activity, as opposed to the amount of funds that you distribute, right? Because that can vary, and that's would anybody else on the working team like to, or working group, like to add anything to sort of the administrative question or different?
Can I just add, I mean, this came up in eligibility and budget review, as I recollect, where a program had sort of combined purposes. They were providing advice about kind of the ways you could get rental assistance. And then for people for whom no other rental assistance, this is during the pandemic, was available, then they had this program that you could act, you know, they could pay directly. But kind of to my earlier point, I think the funds that were spent to provide the advice about and educate people about what forms of rental assistance would be available would not be an administrative cost. And that might include reviewing people fill out an application about why I need rental assistance, and you look at that and you make a decision that, wow, look, given what you've said on this application, we think you're eligible for some other kind of funding, right? But that the actual cutting of the rental assistance check makes sense to me, right? That if you're distributing funds and you're the accounting staff and you're distributing a check. So I just think there's some nuances there in terms of what is and what isn't. And I worry that we could benefit in some way from a definition of what might be in or out. And maybe it's not in the rule, it's in an FAQ. I'm not really speaking to that, but I just feel like it's a bit nuanced.
Juan?
Yeah, I was gonna use that from eligibility and budget, because that example actually came up. And as I recall, when there are a lot of questions of law related to rental assistance, and certainly with appeals and so forth, that the EBR committee, as I recall, approved all of that. That's all legal, very squarely legal. It was just and I think this is what Heidi was saying, that it's just administration of those funds, like the cutting the check, because that organization was distributing a large amount of rental assistance. The amount that's distributed itself is not doesn't count towards it, but the staff time and related costs to that, cutting that check, that program is what would.
So I agree with you.
Administrative.
Yeah, I agree with that. I just think it's important maybe in an FAQ to say that, because when you say things like reviewing the application, I think that's where it gets more nuanced.
Yeah.
And I do think to some degree, you know, that is part of the, I'm not saying I disagree with the FAQ or further guidance on sort of how we define administrative, but I do think that is part of the application review. And some of these questions are best answered by EBR, you know, where they get a little sticky. And I do think that, you know, there's various precedents where we've established, what's been interpreted as an administrative and not, but so it is really intended to not deduct qualifying activities, but, you know, sort of truly administrative expenditures related to the, because there's a lot of money going out through pass-through funds, and so to say that that there isn't administrative funds, that shouldn't be identified and excluded.
Yeah,
I think
I'm
is-
not,
yeah.
I'm not disagreeing with
Yeah.
that at all. I just think some examples, maybe to Selena's earlier point, like some examples of how this would generally be looked at in an FAQ would be enormously helpful and save time on the eligibility and budget committee review because there would
Sure.
be clarity about it.
And I think that as, obviously as we, if, should we move forward and get it approved, I think when we roll these things out for the application, we will need to have, and a minimum of training, if not some supporting, sort of conversations and documents that do sort of help grantees understand where the lines are there. Juan?
Yeah, can I just make a suggestion? And we've done this with other topics, that maybe some type of like chart or something that's for the version that goes to the commission, we'll have that. And I think, some of these examples we've all talked about, right? The rental assistance grant making at an entity. Some organizations provide like, I want to say like a cash aid, like donations kind of a thing. Those are the three that come in mind that I think are more regularly. And if there are other ones, then I think Selena can share it with us and then we can put it in there. I think even those three would be helpful for programs.
Well,
And
I
then
think-
again, like Selena mentioned this, but we implementation, we will then show it again. We do a webinar, we explain to programs, but at least they have it in once it goes out, we send out for public comment, formal public comment. They can have that.
Yeah, and I love the idea of a chart. I think it was very helpful with the new rule and things, so that's a great idea. I would encourage, like in the fiscal sponsorship, to just give an example of what portion might, if it's money you're spending for your staff, like even though it has essentially a pass-through component to a CBO, like you're still allowed to do that, just because it means we've answered questions at the front end that we don't have to deal with at the back end. So thank you.
Are we in agreement that if we just change the fiscal sponsorship language, and oops, hold on. Let me, if we were to change, strike this out, hold on, sorry. Strike out this, and this, that would satisfy your concern about the incorporated, unincorporated question. Okay, so I'm gonna,
I think.
add that as an amendment or a recommendation to change. Should we, oops, I went the other way, sorry. That's what happens when you.
It's all good.
Okay, so,
and then I don't know whether, it seemed like we had started some conversation about sub-grantees and we had a public comment about it. And I don't know whether we had addressed that comment or not. So we had put it off until this discussion, so.
So the working group talked about this particular topic extensively, and I welcome the other working group members to join in. We ultimately made the distinction that a required subgrant, otherwise restricted funds only, should be excluded. Because if you go down the path of all subgrants, that's a whole nother sort of thing. So if organizations are making the choice to use their funds to make subgrants to other entities, we thought that should be evaluated as individually as a qualified or not qualified expenditure, as opposed to an excluded expenditure at the front door. And so that was the distinction we did make in putting this rule together. Go ahead, Erica.
Yeah, I just wanted to echo, I think that was consistent with the way the rule had been created. The prior rule had been created, was always that essentially, to the extent that the grantee has discretion to take any money that they, any of their grant money, and then they opt to then subgrant it for non-qualifying expenditures, that ought to be considered in their like primary purpose evaluation. Whereas if they were sort of given money without discretion and therefore were required to give it, for example, as cash assistance or whatever. I think other examples were like, you had to share it with the medical school, or the grantor, wants to use them as a way to facilitate, some other kind of means that's related. Then we were like, well, then we want to encourage that, and therefore we're willing to like let that come out of the primary purpose. But if they're choosing with their money to then, it's not that we want to discourage that, it's just that the statute requires it to be a primary purpose, issue. So that's why we kept it that way. And I think that's consistent with how the application anticipated pass-through. That's consistent with the way we developed the prior version of the rule, although it was, there were all these examples and stuff there. So I just want to say, I don't think this is that's a particularly new approach. I don't know what to Selena's point about what required is and like where the concerns are there. And we can sort of flesh that out a little bit, and maybe Selena can speak to what the concerns were about that.
My recollection is that a lot of that conversation was the 2021 discussion, because I'm going back into the backlogs of my memory, where it was the discretion piece. So when Heidi read the slide that said if the entity has, if the IALTA grantee has the ability to select sub-recipients of funding, but they're not doing continued oversight, then that oversight piece, that was just where there was a little bit of what does it mean? Because what if they do require their sub-grantees to submit budget change proposals or whatever, or they do require their grantees to report on how they spent the funds and their deliverables, and then they could decide later on not to re-grant that. So it was kind of like devils in the details about what oversight meant with sub-granting.
Right. And I think with this, we tried to take that out of there, like to try to sort of eliminate the cutting so thin on those kinds of things. I think the idea was more just like, if the money was required to go out, even if they got to choose who it went to, right? Even if they had to do oversight, all that stuff, we were going to still let them do a pass-through. But the issue was if the money was to them and then, for them to do with whatever, and then they chose to do a sub-grant to non-qualifying services, that would be the distinction. And we can articulate that again in like the FAQ or the training, but I think that's consistent. Heidi, let me know if I'm wrong though, but I think that was our intention.
Right. I would just add that part of why we revisited this topic is because I think that the 2019 version of pass-through funds versus the 2021 working groups version of pass-through, I don't think we got clarity from that, you know what I mean? And so our intention with just limiting it to these, because the pass-through funds is really just C through E, because the other is just non-cash, that it's a different bucket. But this gives us a much clearer, less subjective decision about what qualifies to be excluded and not restricted. Is it, as an accounting term, there's restrictions for use of funds, so it's very clearly spelled out in these relationships. A little less clear in the fiscal sponsorship, but still, there should be clarity on that. And so the idea is that it takes the guesswork out of what you get to exclude and not, and puts it very simple. Do you meet this criteria? Yes, no. And then, you know what I mean? So I'm hoping that then we can sort of get out of this, I don't know if it fits or not, so there's just certain criteria. So I think it simplifies the topic a lot. Catherine, I do see you've got your hand up.
So for E, for the subgrantees, what happens if the identified subgrantee is another legal services program?
In regard to like the exchange fund question,
guess,
or
I mean,
just our qualified services suggestion?
I really just tried to, like, since I wasn't, which is perfectly fine, not involved in the rule, like I read required subgrantees to apply regardless of the purpose of the funds. And so if you got money and you were required to grant all or some of it to another legal services program, that would not count as a qualifying activity. And I guess I'm just confirming because there's a different way that it's handled when funds are exchanged, but they seem quite similar to me. And so I don't think it's necessarily as clear as if the desire is to have this very clear rule about yes or no, it is or it isn't, because we also have exchange funds, I think there's an intersection there that maybe I'm just not understanding.
Well, there is an intersection that we will get to when we get to exchange funds, and that's part of how we approached the question around exchange funds as well. So for the purpose of excluded funds, we are saying any subrecipient who you are required to give funds to, regardless of whether it's a qualified expenditure or a qualifying legal service provider or not. If it's a required subgrant, it just gets excluded off the top, period. It doesn't matter whether it's a qualifying entity or not. So those required subgrants are treated the same.
So should that be the rule, I guess? Does that make sense to all of us about why you should, when it's characterized as a required subgrantee, exclude it as a qualifying expenditure, but if it's more of an exchange, you should not, and it could be going to the same organization?
Well, we're proposing a change to exchange funds. So in the proposal that we will get to shortly, there isn't an exchange fund deduction. That would go away. And so that so if the required subgrant, that gets excluded from the giving organization. The receiving organization, if it's for to a qualified legal service provider and they use it for a qualifying activity, they would get to count those expenditures. So we are trying to take a consistent approach to subgrants across the board. And so that is part of why we have made the recommendation to eliminate exchange funds as well.
And I guess my last question is, so if you do that, but the organization has some ongoing relationship about how those funds are used, is that doesn't matter because it's a required subgrantee? So you're required to contract with another legal services organization because they have subject matter expertise in an area your organization does not have. And you are required to jointly produce something about this. So those would still be excluded as a required subgrantee.
So what gets excluded is the amount of money you give to the subgrantee. So if you have a staff member who is working with that subgrantee and producing a product that is qualifying, then the money that is spent on that staff person would not get deducted. Only the amount of the subgrant to the subgrant. So if you were performing qualifying work in concert with that subgrantee, that would still be counted.
Okay, so maybe just a FAQ that explains that.
Yeah. Because this is really specific to the actual grant itself, not any supporting work around it, if that makes sense. The administrative work surrounding it does have to be deducted, but if you're doing qualifying work, if you're a lead agency, let's say, county gives you, okay, we're going to give you X number of dollars, you go get two other organizations in the county to do this, and you're the lead agency, you're doing work under that. You've also got other work. The work you're doing with the money you receive under that grant, totally qualifying. It's only the money you're giving to the other grant organizations that gets deducted. So it's just the grant itself.
That is the Measure H issue in LA County.
Exactly.
Thank you.
Any other questions or concerns about exchange funds? Are you ready to move on to, or excluded funds, excuse me, they're both E's. So now I'm going to turn it over to Crystal, and she will talk about exchange funds.
Heidi, before I jump into that, I just wanted to, I think in terms of the public comment we heard earlier, there was a concern about the supporting documentation. I don't know if you wanted just to briefly talk about that, but for the excluded funds and the pass-through funds it might be onerous given the amount of subgrants, but I don't know if you wanted to discuss that in terms of having the ability, in the working group discussed having the ability to verify the amounts. Sometimes they're large amounts, and documentation would, I think the working group identified would be one sort of the way to validate amounts reported and sort of taken off the top.
Yes, I mean, what we're asking for is just the contracts from the two organizations that are the funding organization and the distributing organization, just validating that they're restricted and that they have an obligation to send them out. And so that should be something that exists, and it's just a matter of uploading those contracts. We do have an obligation to ensure that we are administering these funds appropriately. So if we are allowing organizations to deduct from the top, which helps them to meet their primary purpose, I think it's our obligation of oversight to see the contract documents that allow that exclusion.
Thanks. So I'll just jump into our exchange funds topic. You can go to the next slide. Thanks, Heidi. Just a reminder of current practice regarding exchange funds. Currently, this is a requirement only for qualified legal services projects. Currently, QLSPs are required to report all funds either paid to or received from other QLSPs. So these are QLSP to QLSP exchanges. When calculating qualified expenditures, exchange fund amounts come into play here. Exchange funds are typically attributed to the receiving program and deducted from the giving organization. There are instances where there's a contrary agreement, and it's the reverse of that. And then in terms of verification, both QLSPs are required to upload exchange fund agreements for OA&I staff to validate the exchange funds. There's a table below for reference pulling data from the 2023 and 2024 IOLTA and EAF grant applications, just for reference if you wanted to know the total amount deducted for exchange funds for both years. I think that's 17 million and 18 million respectively, compared to the subtotal of qualified expenditures. Okay, next slide. A couple of considerations that the working group thought about in terms of sort of the exchange funds in current practice. One question was whether the current practice, which is not statutorily required, is in support of current practice. I think another consideration was whether or not the exchange funds creates a penalty for QLSPs who opt out to subgrant with other QLSPs. Again, if it's consistent with IOLTA statute's purpose to expand availability, improve quality of existing free legal services, and initiating new programs. The working group also discussed whether current practice disincentivizes organizations from subgranting with QLSPs. If an organization chooses to use their money to subgrant with other QLSPs, whether or not they should be penalized. They are opting to provide their funds to provide additional services that benefit their clients. That was a consideration. And then I think sort of consistent with our earlier discussion of the first topic, another consideration was whether exchange funds leads to an inconsistent treatment of subgrants. Currently, QLSPs are not allowed to count. They are allowed to count money given to support centers and other non-QLSP legal organizations, but this is not the case for those QLSP to QLSP exchange funds. Next slide. I think another point regarding exchange funds and sort of the administration, I think both staff and the grantees who we've heard from in the January feedback session, I think both stated it's very administratively burdensome to report these amounts. And in terms of the benefit, it was there appears to be a return on the effort is relatively low. And then reconciling the available information is also difficult. This can be because the amounts are different due to varying fiscal years or the amounts spent for each year. The supporting documentation in some instances is also inconsistent. We sometimes see grant agreements, sometimes another who gets to count the money type of agreement. So that's inconsistent from what has been submitted. And then some organizations require subgrantors to allow that grantee organization to count the money, which the working group had some concerns that it would create an inequitable power dynamic or contribute to that. And then if a QLSP exchanges funds with new grantees who have not been deemed eligible for IOLTA EAF, they do not have to deduct those funds. But that was another inequity piece that the working group observed as well. Next. Great. And then Jonathan, feel free to chime in for the working group recommendations.
Thank you, Crystal. Based on what Crystal just shared, the working group has decided to discontinue the practice of reporting and deducting exchange funds. At least that's the recommendation. Another recommendation is to align with plain language reading of Business and Professional Code, section 6216(1)(a). And the last one is consistent with the Legal Service Trust Fund Commission's existing recommendation that qualified expenditures include all state board grant expenditures. The working group recommends that any funds paid to or received from other QLSPs would be allowed to count as qualified expenditures.
Great, thank you, Jonathan. And then just recapping the feedback points both received in January and March. I think because of that administrative burden, grantees, I think were responded favorably in terms of reducing that burden for future IOLTA EF applications. There was some concern, of course, about the impact and how that would impact their respective allocations. There was one proposal about a discounted or prorated deduction instead of an all or nothing approach. And then the working group had sort of discussed that, and the pros and cons are outlined in the memo, but ultimately did not sort of update its recommendations or to reflect this suggestion. Okay, next slide. And then Heidi had talked about this earlier in terms of the proposed approach, recognizing that we did send a rule out previously regarding qualified expenditures. And now that the working group has had a chance to talk about exchange funds and sort of where it would belong in the larger picture, the changes you see here sort of are both the qualified expenditure and then adjustments reflecting the I believe red are the amendments to the rule, and then blue is what went out for public comment. So you see it here integrated because the working group felt like that was probably the best approach in discussing exchanged funds because of the funds paid to and received from QLSPs. Okay, that's the end of this particular section. So end of the day, recommending to not have the exchange fund deduction anymore. And then feel free, like any Jonathan, Erica, Jason, you're also on the working group too, if there's any other feedback or points you wanted to share regarding this topic.
Not seeing any hands up.
Oh, Selena.
I think that my question, I'm sorry, I've asked this question so many times, but I just want to hear it to make sure I'm totally clear on it. So if in a hypothetical county where organizations are in the habit of subgranting, of exchanging funds between each other for, maybe referrals or something like that, how would this impact the other organizations if the organizations that are in the habit of exchanging get to count that on each side? Or am I not understanding how it's counted?
With the proposed recommendations, both sides would count everything. Heidi, feel free to chime in too. I know that question came up in terms of overall impact. I think LA County we talked about as a hypothetical as well. I think anticipating amounts would go up, but again, I think the working group had talked about this. There's so many factors in the allocation process. Like it's really hard to ascertain like what that impact would have. And there's other recommendations impacting qualified expenditures as well too. So they would both count it in terms of like overall impact. I think we're not really sure of what that would mean. And I think echoing sort of the intent principle over impact for these recommendations and providing clarity and streamlining and lessening administrative burden, I think was part of the working group's purpose. Catherine.
So now I guess Selena was asking the question I've been thinking about, which is like with Measure H, which I think had $20 or $30 million. And so it went to one qualified legal services organization who then did significant subgranting to a number of other LA County organizations. So under so and might just be misunderstanding because I thought I understood it till Selena asked her question. So would the first organization count the 20 million that it received and subgranted? And then each of the receiving organizations, let's say there were 5 of them or four of them, and they each got 5 million. And so we'd be reporting a total of 40 million as opposed to the 20 million that was actually received.
So so under the measure H is they're required to subgrant, correct?
I don't know that they're required to subgrant, but that would be the model that would probably work. And they did a lot of the coordinating about it.
Yeah, I feel like, and I could be wrong, but I do believe in that instance there's a requirement for them to, send it out to community partners, which in case they would fall under the excluded funds, and only the actual work done by the qualified legal service providers with that fund would then count in the allocation model. So yeah, I think there is a requirement there, and so it would.
But it wasn't required who they contracted.
It doesn't matter the who, doesn't matter. It's just that they must contract it out is the requirement. So in our excluded funds, if you are required to contract out, it gets excluded. It doesn't matter who you send it out to. It's just the requirement to send it out. So in that instance, I believe that's an excluded fund, so it wouldn't count. In the other instance where it's not required subgranting, then each organization would get to count it because it's a qualified expenditure on their audited or it's an expenditure on their financial statement. And so sort of this you get to count it here, but you don't get to count it there. It creates this. I understand in theory why we think it's a good thing, but in practice it doesn't actually work, And so I think it has more issues than benefit, I guess I would argue.
Say I do not know that the assumption that they were required to subgrant is accurate at all. And I really think it's worthy of some better understanding of, let's just assume for the moment that they were not required. And so therefore it would not fall under the required subgrants exclusion, but would instead fall under the exchange. And I'm just noting that $20 million counted twice has implications, particularly for those organizations that were not the recipient of a share of the money, right?
So I did do an analysis for Los Angeles specifically because of this issue, and I know the organization you're talking about, and so it was excluded under the exchange fund, and the difference for organizations was about a 7% difference. So it wasn't as big of a swing as you would imagine, but and so
I still think 7% is not insignificant if you're a small organization in LA County and the big partners got the money and you're a smaller organization and you didn't, and now you lost 7% of the.
That is sort of the nature of our allocation model.
I understand that,
so we're sort of forced in that model. But I know, Selena, you've had your hand up, and I see Elizabeth, so I'll let you chime in.
Oh, it's all kind of on the theme, because I think this is kind of worth a discussion, because if there are instances where we are at risk of double counting, not only does that impact the smaller programs in the community, but also the story that we tell about the cost of the provision of legal services will be skewed, and it will look like we as a community are spending more than we actually are spending, which is hard when we do statewide advocacy. But as long as there's some way to know that approximately X% is an overcounting, then I can know that. But if there's no tracking of that, then I don't know how much we're spending in LA County, for example.
each organization has a financial statement that reflects their spending. Money goes from one organization to another all the time. So the idea of over counting and only isolating it in this instance, I think is a bit of a calculation, because grantees are giving money to support centers for the same purpose. That's, you're not deducting that from an over counting perspective of what's getting spent. So it's like this idea that you're just looking at this one narrow place where you're considering that a double counting, I think makes your data a little inaccurate anyways. And that's, I think, part of, if we want to go based on what's an actual expenditure on an organization's financial statement, that money came into them, it went out to them, and you can just, if you want to have them report expenditure related activities to subgrants, that's a different question. But sort of excluding it in this one instance, I don't think actually gets to that, answers that question. Go ahead, Duan.
I was just going to ask the working group members, and I am curious to hear from the other work group members as well. Is one of the reasons to exclude it to streamline and make it easier for programs and staff? Because I guess where I'm going at is, if I'm hearing from Selena and Catherine, and I don't know if I disagree with this, I actually may agree with this, I'm just still thinking about it, is that it could move funds around maybe in an unintended way and have an impact on programs, and how large it is, how small, I think that could be debated, but that's, I think, the on balance of if we're trying to streamline it, at what cost, and does the commission, I'm trying to zero in on what this debate. So I guess I'm curious to see the why in which the working group chose to exclude it. Is it because of streamlining, or maybe I'm missing something?
I also think there is one point that hasn't been made, and I don't know if Jason loves to speak to this point. So I'm going to let you, because I think I know where you're going, Jason. I hope. If
I
not,
don't know that
I'll
I'm going to, but you can help me out.
Let's see.
So I think there are two things that I want to speak to if we're talking about this $20 million, to the extent it's required versus not required. To the extent it's not required, I don't know that it is a reasonable expectation to have a system of exclusion that attempts to counteract the ripple effects of a $20 million direct grant to that recipient, and then their subsequent choice to subgrant it out to a qualified service provider, right? So we could then say we're double counting it, and that negatively impacts the smaller organizations. Sure, but so does $20 million directly to the large organization. And that's the direct impact of that is going to happen regardless of whether the model tries to correct for it, because they're going to get the bulk of those funds. I think the other reason why we talked about excluding it was that there's excluding the required versus non-required is, if it's required, there's not an executive choice being made about how to use the funds, right? They could be used internally or they could go out. And so whether it's required to individual recipients or required to many recipients, the point is their choice has been removed from that factor on the overarching disbursement of funds, as opposed to, not having or having that choice. And then therefore, presumably there's some degree of relationship there. We did talk about in our group some degree of, should it count as a percentage count, right? Because if you've got choice, there's something going on in deciding to subgrant out, if you have the ability to choose to do so or not. And that has some value attributable to it, right? If you don't have to, but you're choosing to. And I think in many ways, if you are choosing to, as a large organization, you aren't required to, that's probably something we might want to incentivize on behalf of those smaller organizations, so that they are recipients of those subgrants. In the absence of a mechanism to incentivize the larger organization to do so when they have the option, those subgrants may not exist at all. And that is a significant concern for us, for some of the same reasons we've been talking about, which is trying to incentivize or create structures and systems that facilitate these smaller organizations coming up and developing and being part of the greater service community. I think that's important. And we don't want to create disincentives that discourage larger organizations from being part of that process.
Catherine, do you want to go?
Okay, I guess two things. So I appreciate Jason's comment that there's going to be a $20 million increase to some organization. My concern is that under this, there would actually be a $40 million increase in that county because both the granting organization would count the 20 and the other organizations would count the equivalent of 20. So the impact in the county is 40 million, not 20 million. So I think that that's just not insignificant. I also like simplifying the rule, and it seems like what, like choosing if regardless of whether it is required or not required sub-grantee, that you simply say, if you're sub-granting to another legal service organization, they count it and you don't, which addresses like, then you're gonna, hopefully it'll be smaller organizations and they'll count it, but the big organization won't count all 20 of it. They'll count the 5 million that they kept to do their work, and they won't count the other portions, which is what seems fair to me, who's actually doing the work. And I don't think the reporting of that would be that complicated. You would have the grantee indicate, the large grantee indicate who the money went to, and they would be reporting it.
So I think that second point, Catherine, is absolutely valid. It is something we talked about and kind of batted around to try to figure out how to do this. And I think that concern about incentives was a large factor because, if they can only count the 5 and they have the choice to not give the 20, right? Are they going to give the 20? And I appreciate that in many of these organizations, like there's a greater value system at play driving some of this stuff. But when we're talking about financial models, I think it's reasonable to expect that there's some incentive disincentive structure that we should be mindful of. And we were concerned about going with what is, I think, by the letter, the most fair, but in application might have, these unintended consequences of reduced outcomes. And I think that the challenge in the rule construction for us was it's so hard to know with clear predictability and clarity what would happen in a scenario. It is entirely possible that, our concerns about incentives and disincentives are completely misplaced and everything would happen as it has been in those scenarios. In which case, then what you've described is probably preferable for all of the reasons you stated. And we talked about that, but our fear was those negative implications and how easy is it to spot those things and then make adjustments responsive to those negative implications to catch them before they become too drastic in the negative impact. And I think we grappled with that for a decent bit. And I don't know that we felt super warm and fuzzy about everything, but I think we landed on the place we did because it was at least responsive to the incentive structure we wanted to create. And I think, we talked a little bit with Heidi about trying to, on the back end in counting, like to try to figure out ways to avoid this 20 plus 20 equaling a $40 million, even though it's like, it's 20 plus 20, but it's like this 20 went to that 20, right? And so it's really tracing it. And I'm not sure if that's overly burdensome to staff to try to get around the implications you're concerned about, but that's absolutely valid and something we were concerned about as well.
So I don't actually have a great solution to this because, our application where this gets played out is in the application, and it's actually called exchange funds. And so programs have to report out when they exchange funds between other entities. And it's a very tedious process for both the staff and the programs. And we spend an enormous amount of time trying to reconcile those numbers during the application period. So I was going to say I liked Catherine's suggestion in terms of like making it really clear to the programs, like this can only be counted once. And I think we tried to communicate that. Where we have struggled, and I think where this still remains the case, is then how do we reconcile that? So we want to do away with exchange funds, I think is what what we're trying to get at. But the thing is, if you do away with it, are you saying there's no mechanism to figure out whether somebody double counted or triple counted? I think if you save it, like, I think we've even contemplated in previous years, what if you save it for monitoring visit? But the thing is, if you save it for at a juncture that's not the application, if they have done it wrong, then how do you go back and redo their allocation? So this does get back into like at what are oversight and how much you want to make sure ensure that all the funds are accounted for only once. And I don't have a great solution, but I do recognize the dilemma. And I hear what Catherine and Selena are saying about we don't want the 20 million to be counted as 40 million. I do think that is problematic. And it's not just a Los Angeles example. There's a San Diego example that's similar. There's a Bay Area example. It is happening in pockets of the state that, again, if you count it all up, could have an unintended ripple effect that's moving around funds like we didn't intend. Again, I think I feel for the working group that worked on this. Again, I don't know where we're at a place that we're all comfortable with. I'll say that.
Can I guess I'll say maybe a solution. I mean, I think I was pleased to see you addressing kind of the power differential. At least that's what I heard, like in the memo, it talked about the power differential. And I think by choosing to say, like, so right now organizations have a choice. They can keep the money and report it even if they're giving the money away, or they can allow the other organization to report it. And I think by being clear that you don't get accounted, if someone else is doing the work, they're the ones that get accounted, really is significant in terms of changing that construct and the power differential. So I think that's really helpful. And I wonder, like, I having entered into agreements and having to have both people sign them, is there a reason where you would just require the agency that got the money to say, we got this money, we're distributing it to these other 5 organizations in the following amounts, and you CC those other organizations with a note that essentially says if they disagree with what you've said, they should tell you in the bar about it. So it's only a one-way communication, as opposed to this, I say something, the other person has to sign it, which just, like, it's complicated. So I think there's some streamlining about how you report it that could be helpful and not have the unintended consequences of double counting significant amounts of money in a county.
So I know that the report that we got, the agenda packet, acknowledges that the purpose of this change is to better honor the intent of the IOLTA statute. And I'm not really clear whether the IOLTA statute cares about double counting. I mean, all of us are sort of offended by the concept, and Catherine, I totally take your point about the anomalous impact on the skewing of the percentages per county by organization. But I'm just wondering what is the IOLTA statute actually intending to accomplish? You take $20 million, you give it to organization A, they spend it in a way that creates qualified activities by giving it to organizations B, C, D, and E. So that doesn't offend me. Yes, there's a possibility. I mean, Jason's point that you got $20 million is the elephant in the room. It's the boulder dropped in the lake, and yes, it's going to have big ripple effects. But so it seems way more complicated to create additional communication streams and levels of proof and documentation and all of that. I'm not really sure the statute requires it. And if the statute doesn't require it, I'm not seeing why we would incorporate it. So that's one thing. And then question number 2, I hesitate to say this, but I'm gonna say it anyway. I'm not sure that it's our role to totally rethink and redo all the work all the thinking and all the analysis that the working group did. Maybe it is. I really think it's important for us all to understand what the working group proposed and to comment on it and test it, sort of. But it doesn't make sense to me to redo it. So we have one agenda item, and it is an hour and a half into our meeting. So I just raised this as a new question for the group, like, what is our role here and what are we trying to accomplish? Also, so that's a process question, and the other one was a substance question. So I'm guessing staff can answer my substance question, and we all together at some point will answer the process question. Jason, you want to say something? Unless staff has a comment, I don't know whether staff wants to respond.
I was holding so that someone could respond to you, patient.
When I'm in presenter mode, I can't figure out how to raise my hand, so I'm just being patient. What's your process? Ask me the process question again, patient. So because I have a lot to say about what you just said and other things, but
so really, I think the process question, the members have to figure that out. But the substance question is, what does the statute intend?
Okay, thank you. Yes, thank you.
Yeah,
so
okay.
the statute is silent on all of this, and that's why we went with the recommendation on the grant, on the state bar grant deduction question, because all it says is total qualified expenditures for civil legal services. And so I appreciate how you put it, patients, because I think it's a much more eloquent way of stating the statute's language. Is just very simple: qualified legal services. So I personally sort of agree with the idea that if I as an organization have X number of dollars and I decide to give it away, I'm choosing to spend my money on a qualifying legal services, and I don't believe I should be penalized for that. And in this instance, you are penalized if we make the receiving organization be the one who gets to count the funds. So, so I can pull the statute language if that would be helpful and present that if you want to see it, but it basically says just qualified legal service expenditures, basically.
So I wouldn't like to see us step into the role of OCG and interpret the statute if the proposal that the working group has made does not offend the statute. Then I would be supportive of the language as it's proposed right now. Okay, Jason, thank you for that.
This is just a curiosity question, and patience. I really appreciate your process question. So I'm going to keep it very narrow in furtherance of the implication of said process question, in my opinion about it, which is to ask staff, how difficult would it be to have some way of, I think Catherine kind of alluded to this or stated some mechanism to allow for us to trace when these things happen, to mitigate, we'll say, some of the negative formulaic impacts of, we'll call it double counting, while still being equitable to all participants in their roles relative to each other or whatever it may be. Is that feasible to do, or does it, like, if you try to correct it on one end, you just move the problem from one spot to another spot?
One of the things we did look at as a working group was one of the challenges is when you give the money, the granting organization has one fiscal year, they give the money in either a reimbursement model or in a bulk model or something, and then there's, on the other side, you have the expending organization that receives it and spends it over time. And so the reconciling the gift and the expenditures are not necessarily you know, tracking over the same fiscal periods or the same application periods and all this. So you would have to develop a system that clarifies, okay, grantee organization gives a sum total of X number and in these things, whereas and it reconciles with this fiscal year versus the receiving organization receives it and spends it over this. You have to do some reconciliation, and it's almost impossible to do. I mean, that is sort of the model now, right? And it is painful, and it is, I think, riddled with inaccuracies, and I'm not sure we gain a lot from the exercise, in my personal opinion. And I also think it creates this differential of, okay, this grant we treat this way, but this grant we're going to treat this way, and this grant we're going to treat this way, and this grant. So it makes this uneven treatment of grant funds depending upon the recipient, that the working group was really uncomfortable with. And so I think it just moves I think it just changes I mean, we could build a model where there is a better reconciliation model. But I think it just makes it still incredibly administratively burdensome. And so I know that Erica and Elizabeth have had their hands up for a while, so I'll stop talking.
I'll wait till Elizabeth goes, and then I'll make my comment.
I was just gonna note that General Counsel has reviewed the recommendations and that this recommendation is permissible under the statute. So there really is a policy decision for the commission to make. And then I know that there's a lot of, discussion about, how, double counting and that sort of thing. But because of the way the allocation formula is set up, there are so many factors that influence what the allocation is, including getting 10 new grant organizations in a single year, that, the model that Heidi did related to this is useful only as like a discussion tool, but it's not, we could not say with any certainty that it would impact the allocation in that way. So I just wanted to point that out.
Erica, did you want to speak?
Yeah, I mean, I just, look, I will tell you, like, I was on the working group that did this rule before, and double counting was like a really big deal, and that, or was sort of the driving thrust in how we did the previous version, which for various reasons never got formally codified. And, in this working group, we sort of taken a different position, and, so I I am sympathetic to, like, I guess, both sides of this, having advocated on one and then, being on this working group and sort of talking through some of the administrative issues. I think part of the points that I thought were persuasive as to eliminating it, beyond that it would be, easier administratively, the fact that, to Elizabeth's point and Heidi's point, that it's, this changes impact on the allocation, seemed, pretty unclear, and it wasn't really sure. It wasn't really, there are so many factors to the allocation that we couldn't sort of necessarily isolate out just doing this exchange fund change. And also just the fact that, the power differential issue, if we just do where only the entity who gets the money gets to count it, does that incentivize big organizations that get a lot of money to just keep their money and not to share it, right? If they don't get to count it on their QEs. And I think that was that point, plus the administrative issues that were flagged. Plus, frankly, when we did go and have staff did present this and allowed the community to come in, their comments while they flagged the impact were, not overwhelmingly concerned on that point. And my recollection was that I don't think LAC's letter to us in response to it had any major concerns, although Selena can correct me, but you know, we did sort of throw this out because we were concerned about it and did not hear a lot of significant concerns. So I just wanted to put in my 2 cents as someone who's been working on this for a few months.
Catherine? Catherine, did you want to speak?
Sure. I was going to let Jacqueline go first because I've spoken a lot, but I'll just say, like, if the question, like, being in a place where one says a qualified expenditure is simply passing through money, as a definition, like by definition, you're saying if you just give the money to other organizations and you're doing no work, it's hard for me to see how that's a qualifying expenditure. Because you're not providing legal services. The organization that is getting the money is providing the legal service. And I worry that we would be in a position of having to explain how that's consistent with the statute.
Thanks, Jacqueline. You're muted.
Okay, wow, this is a really great discussion. Very robust, very thorough. I really appreciate it, you know, because as a new commissioner, I mean, it's a lot to take in, and all very important issues. I really appreciate, you know, the effort and concern about simplifying processes as much as possible. You know, but I just can't. And I really especially appreciate all the points that Erica and Catherine and everyone else is making, but I can't see around what Catherine is saying that, you know, I mean, double counting and, you know, I think it's very important that the organization that does the work be able to count, account for the money. But, you know, at the same time, I don't know exactly how to reconcile all these different issues. Is there a way, maybe with, do we have an accounting protocol that we can rely on to help to organize the accounting in a way that these issues can be addressed through accounting methodology? Do we have an expert accounting to help with this? Because I just think that that's what it needs. I think we need to rely on an accounting method.
Well, we have a whole fiscal team, and Heidi and Michael are resident fiscal
And
accounting.
can I respond to that too? This is a big accounting fiscal related issue. One of the difficulties is in reconciling the exchange funds is that grantees have varying fiscal years, and it's not just calendar year or, you know, July through June. Some start in March, some start in April. I mean, that's one of the difficulties in reconciling. And then depending on when you receive funds, and when the organization grants the funds or gives the funds to the other grantee, it's you know, in my time looking at exchange funds, I've had very complex spreadsheets trying to track where and how the funds are being distributed to the other organizations, and so that's why it's difficult for us to verify.
You know, I'm so worried about what, you know, what Erica was saying about then the larger organization that gets the money, then maybe this will, you know, make them less likely to want to, you know, subgrant out the money. That's a problem.
Yeah, can I make one other point though? And I want to make sure I understood this, because this is something that I understood from and staff can correct me, but an organization that gets our money and then subgrants to a non-IOLTA funded organization that provides indigent legal services gets to count that money. They don't have to exclude it even though they don't provide any of the work. Okay, so I just want to flag, the only reason the exchange fund comes up is because the money's being given to an IOLTA entity, not because it's being subgranted. So I just wanted to flag that, because if the issue is you shouldn't get to count money that because you didn't do the work, well, then we are opening up that whole other basket, right? Which says any subgrant basically should not be counted as qualified expenditures. So just flagging, and correct me if I'm wrong, Heidi and staff, if I have that misunderstood, but I believe that's the way it works
No,
currently.
that's right. I think that's a good point, yeah.
Ready?
Sorry, I can't raise my hand, get in line. Or
It's
if I
all right,
can,
we see your hand.
I don't know how. So two points I would like to make. I'd like to push back a little bit on the idea that a subgrant is not a qualifying legal service activity, because I think if I, in my prior life as a nonprofit leader, when we had a service that we could not provide, but we had funds that we could provide that would benefit our client, we would choose to use our funds to say, hey, coordinating, program, we'd like to give you money so that you can use your service expertise to provide this service to our clients. So by giving money, by subgranting with another organization, we were furthering the benefits our clients were receiving with our funds, but just with someone else's expertise. So I don't think the fact that giving money to another organization just means it's not qualifying if I didn't provide it. I'm adding a value and a service to my client population by subgranting out to somebody else who is qualified to provide that service where we're not. If we are qualified to do it and we have the staff, I just do it myself. So I do think that there is, I do think that the grantor organization in this model is penalized for choosing to use their fund to further the services for their clients through subgrant relationships. So I would like to just sort of frame that a little differently, because I think Catherine and I may disagree on that. And then also, yes, to Erica's point, 100%. In this, if you subgrant out the same exact money to 3 different organizations for the same exact purpose, let's say, the non-QLSP grant organization, you don't have to discount it. The QLSP organization, you do have to discount. The support center, you do not have to discount. So it is only the QLSP that you are having to deduct that. And I think that does disincentivize our grantees from doing that, because if I've got money and if I give it to my next door neighbor and I have to deduct it so I get less money, then I have to really think about what am I going to do? Am I going to do that? So, and to respond to the accounting question, Jacqueline, we are looking at records from each organization's accounting records, and so it's trying to make them make sense, and they don't make sense in the same pot. And the allocation is one pot at one time that's taking how much money did you give away from this organization and how much money did you spend from that organization in this fiscal year ended in this year. And so it's apples and oranges that we're using to make these deductions. So these deductions aren't actually they don't reconcile at all in any way in one given funding pool year. So, the organization could have given $5 million in their fiscal year to the other organization, but that organization may have spent that $5 million over 3 years, right? So the grantee organization is taking a $5 million hit in one allocation year, whereas the increasing organization gets a periodic increase to their allocation over multiple allocation years. So it doesn't quite work in this double counting sort of world, because we're doing it one allocation year at a time. And so it's this sort of it's this false notion that we're eliminating double counting, but it doesn't quite work so simply because of all of the different rivers we're trying to step in and out of at the same time.
Catherine, I see you've got your hand up, and I do want you to speak. I really want to think about wrapping up this part of the conversation, because we still haven't talked about county expenditures, and I don't know about everybody else, but there's a lot else going on.
I'll just quickly say that I think we're mixing apples and oranges because the other examples, when it goes to a non-QLSP, means it's only being counted one time by the organization who's choosing to spend its money someplace else. So my concern has always been that two organizations are counting it, which I just find not the best way to explain things in terms of a qualified expenditure. So I'll leave it at that, and I'm fine moving on. I think it's been a robust discussion.
Thanks. I mean, you've had your hand up and down. Do you want to make a comment? Is there anything you want to add?
No, I don't think I have anything more to add to the conversation. I think the points that I've made, I've raised my hand and brought it down because other people are making the same points or addressing the questions that I've had. So I appreciate the discussion and
Thanks.
happy to move forward.
Okay, can we move to county expenditures then?
And thankfully, this is a pretty simple, straightforward one that shouldn't take too much brain power to get through. All right, so the current practice for county expenditures, and just to paint this in a little perspective, this only relates to QLSPs. Support centers do not have to report by county because their funding model is not based on county expenditures, whereas qualified legal service projects expenditures must be broken down by county by statute, and that's how we distribute them. So this is just a topic solely for QLSPs. So the current practice is that QLSPs report all qualified expenditure by county in their annual application. There's no clear guidance regarding the methodologies required to track the expenditures. There's no rule. It hasn't been codified at all except for the language in the statute. And then there's some guidance in our application materials. Currently, there are sections in the county reporting expenditures where we have discontinued counties, which are counties that you've used to have an IOLTA and EAF allocation for, but are no longer wishing to receive an allocation in that county. Or there's a category for out of county expenditures where expenditures that happen outside of the allocation counties that you have can get reported. And then and there is a section where you can ask for where you want a new county allocation. And under the current practice, counties or organizations have been allowed to take the discontinued counties and or out of county expenditures and apply them to home counties and or across the counties they serve. So that's the current practice. So upon further review of these practices, our State Bar's General Counsel has recommended that allowing the QLSPs to count expenditures outside of the county for which they benefit is not in line with the statute, and so we are discontinuing that practice. And so going forward. And so, sorry, the consideration. So, and then also because there is no formal rule and not a clear line on how to report expenditures by county, and the current practice has a variety of different models and levels of rigor that each of the organization are using to support their expenditures by county. So those were the considerations that the working group had when we approached the county expenditure question. And so then I'll turn it over to Jonathan to describe the working group's recommendations to move forward on this issue.
Thank you, Heidi. Given the three considerations, the working group has made the following recommendations: to clarify that county expenditures can only be counted in the counties where the expenses occurred, clarify and codify existing guidance regarding county allocations, define permissible allocation methodologies and relevant factors that must be included, and define the frequency of how often the methodology and or source data must be updated by the applicant.
Sorry. thanks, Jonathan. And so again, at the grantee feedback session that was held on January, there was no clear opposition to this. There was just more questions about sort of the how and sort of how to count expenditures and in which county and sort of various questions and some questions that sort of that kind of like clear, that made it clear that some organizations don't fully understand this requirement, and because it is an existing requirement and practice. So this would only be codifying what's required in the statute. And then the feedback that came in from LAC in March just further emphasized that there's the need for frequently asked question documents, or just to help the community understand these requirements and how to best understand the county expenditure requirements. Okay, and so this is the proposed rule. Much of this is taken from existing language in our eligibility guidelines and our application instructions. But in essence, it's just basically, clarifying and codifying that if you serve more than one county, you do have to have a basis for your by-county allocations. It must be reasonable and reasonably related to the geographic distribution of the indigent person who's benefiting from the services. And that must be, a reasonable model that's related to actual expenditures on the fund for the indigent persons in any given county, and that it must be reviewed and updated at least annually as part of the application process. And so then there's some, sort of factors that the commission can consider to determine whether or not it meets the reasonable standard. And so this is sort of the proposed rules. So welcome any other comments or questions or that the working group would like to make, or questions from anyone?
Going once, going twice. Okay. So are we ready for a motion, or is there more?
So we do have a proposed motion, resolution, that I can read that should you agree that the Rules Committee of the Legal Service Trust Fund Commission approves the working group's recommendations related to excluded funds, formerly pass-through funds, exchange funds, and county expenditures as referenced in attachment A, and I've added as amended in the Rules Committee meeting on March 20th, 2024.
Thank you, Jacqueline.
Yes, I just wanted to ask, in the other sections that we discussed, was there something, I think there was a line or something about being subject to accounting rules, accepted accounting rules and practices. I don't know, remember if that's according to the American Accounting Association rules and regulations, or whatever other required organization or recommended rules we have to follow. Was there a section that mentioned something like that? I think there was, because maybe we could, I think that should be aligned someplace, subject to, the ACC, American Accounting Association, that I'm familiar with, but I don't know, with the Bar Association, there's maybe other organizational accounting guidelines that we have to follow. If that is included, I think that's very important, because, we haven't really fully addressed this issue of debt.
Uh-oh,
You want to simplify things?
We missed the
Yes.
last few seconds of what you said. You froze for a sec. Could you repeat that?
Oh, okay. So I don't think we've fully addressed, is that the part, I think we have to put in a line about accounting methodology someplace. I don't know if we follow the guidelines of the American Accounting Association, or that's one I'm familiar with, or some other rules and regulations specific to the Bar Association. But because we haven't really fully addressed the issue, And we're trying to move forward, I think, without doing that. And I think the problematic issues still exist. I mean, I'm still thinking about them. Like, okay, we're going forward, but we didn't really resolve everything about the double counting and how, you know, it may be unintentionally when we do that, we may be creating this situation where the larger organizations don't really want to do sub-grant out and give out their money. If they're not going to get credit for it, they're not going to get to count it because they're being sort of like penalized in another way.
So I'm
It's
not,
not quite where it just doesn't seem like we're
so my
quite
question
where we
is,
need to be.
my question is what, I don't know. I know that when I was in ED, when we got audited, we had to, you know, the generally accepted accounting principles, GAAP, was the standard we were held to. I'm assuming that's the standard everybody's held to.
That's correct.
I think the unintended consequences, Jacqueline, you point them out, and Catherine's pointed them out, and Jason's pointed them out. We don't know exactly what they're going to be, but it sounds like the working group anticipated that there could be, and the thought is to sort of monitor how this is working and course correct if it turns out that there are incentives to, you know, there are disincentives to do the right thing. Or no. I do want to ask Jonathan, I saw your hand was up.
Yeah, I put it down as I was trying to get clarity on Jacqueline, but she didn't state that she's talking about the double counting rule. But I agree with Patience in the fact that if we're talking about any 501c3 grantee or an organization that's fiscally sponsored, they're following GAAP accounting, because a fiscal sponsored organization, their sponsor, whether it's Tides or community partners or any other that's in California, they're following GAAP, and so is a 501c3. So you're absolutely right.
Catherine?
So I hear, Patience, what you're saying is approve the rule and have it go through the public comment period, be approved by the Board of Trustees. And if in a year we find that it's a problem, then we would revisit this. Is that, like I heard you say, we can course correct, but it's a rule, right? So it has to go through this kind of cumbersome process.
That's my understanding of the plan, is that because we cannot predict with certainty. I mean, everybody's guessing, right? Will there be bad incentives? Will this be incentivize what we, you know, good? We don't know. And what we do know is that this proposal is not a problem in terms of the statute. And since nobody knows what's going to happen, and we can just guess about it until the last dog dies, but let's not do that if we can avoid it. And so at some point, like so many things, we're going to have to move forward and do the thing. And then if it turns out we did the wrong thing, yes, we're going to have to correct it. I mean, that's my understanding of what.
So I would feel more comfortable then doing that if there was some language that said we're going to monitor this so that the commission has information about in what occasions did this happen, so that it's just a bit more formalized. Because honestly, I'm still troubled only by the exchange part. I think the rest of the resolution is fine, but if there's some language that we can add that speaks to what you said and that we're actually going to have some data about it that we can look at, then I think that would change what my vote would be.
So Jason, I see your hand, but I'm going to call on Dwan first.
I was going to say there is a member of the public that has their hand up, and then I was going to ask Heidi and Crystal this question of like, even before what Catherine suggested, is there a way for us to gather that information to monitor?
This is Elizabeth.
I don't know.
I'm going to speak on their behalf right now. I think we can probably, if this rule goes into effect, we can look at the data, how it impacts, I guess, allocations and count by county.
But you wouldn't know how many, like who's counting it unless we collected more information. It's why
We would have to collect more information, yes.
Yeah.
So let me ask Jason to chime in and then we'll get back to this.
So I think, and this goes patience to your process question earlier, and I think, you know, from a governance model standpoint, at this level, the options are basically twofold. Like one, we can move forward with the working group's recommendation because we think on balance it's worth moving forward. The alternative is basically to say the recommendation as presented for the reasons, you know, that follow whatever are seen as, this is going to sound stronger than is intended, but it's the word choice that comes to mind, for one reason or another, intolerable or unacceptable, right? And so we punt back to the working group and we say, you know, revise in a way that addresses these things, right? I think in our current instance, we know the implications are, if the revision is such that what is being proposed by the working group is not going to pass muster and something that folks are comfortable moving forward with, the likely alternative is something that either tries to balance, right, in some way with a greater degree of reporting who gets to claim on the exchange funds, because that's I think the one that's been the topic of debate, or the alternative, which is like, okay, well, you can't double count, only the recipient gets to count, and the implications will be what they are there too. And I think we can use our imaginations to figure out which rule would be most maximally tolerable by members of not only the working group, but also this group and so on and so forth. I think that's really the question, because as Patience said, the outcomes that could happen from all, like, they're all really unpredictable and hard to know how that's all going to play out. So we're really operating from the principal standpoint of like, okay, we want to create a structure that does incentives, but the alternative principles of we really want to preclude double counting because we find that, I mean, again, for lack of a better term, we find that offensive to the greater goal of what we're doing. Also fine. And I think that the response would be that if that was the vote of this group, would be to kick it back for review. And
can I just,
I'm going to ask one question before I call on you, Catherine, and that is asking the members of the working group. It sounds to me, correct me if I'm wrong, like you actually have given extensive consideration to all these questions about what might happen if we do A, would it be fairer if we do B? I mean, the questions that we've vetted today are a revetting for those of you on the working group. If that's true, maybe somebody could help me understand what would be different. Like I don't want to bounce it back to the working group. If the working group can't, like, what else can you bring to it? So that's my question, but I'm going to wait until Catherine speaks until you answer.
I was just going to suggest a slight a modification of the proposed resolution that would say it's something like, it's further resolved that the Legal Services Trust Fund Commission staff, or whatever, however we define that staff, will collect information to help the commission evaluate any impact of the changes on the exchange fund rule. So that we're just saying that that's going to happen and leave it to the staff to figure out the best way to do that and report to us whether, as the working group thinks, there might not be any impact, or maybe there is an impact, but we would have the information. So I'm not suggesting it go, the duality of the choices, we pass it or it goes back to the working group. I think there's a third choice that would provide us with information. So as the commission, we can understand if there is any impact on the change, and then decide, as you suggested, Patience, earlier, that we can course correct if there's a reason to do that. And if I'm wrong about there's like, it really mattered, it didn't matter, make a difference at all, that's like good to know too.
Okay, staff, multiple staff have hands up.
So I just want to remind you, there is a public comment. You don't need to take it, but there is a public comment.
Okay, thanks. Let's hear from staff and Amin, and then we'll take the public comment. Thank you, Duan. I don't have a way of seeing when there's a public comment. So, okay, so. Crystal.
Yeah, I can go. I think I just wanted to just follow up in terms of that proposed amendment to the resolution. As a reminder, the fiscal codification working group has several topics in line that will be impacting qualified expenditures and which go into line with the allocation factors. One of them, the most recent one, was that all state bar grants would be counted as qualified expenditures. I think I'm struggling in terms of what the follow-up would look like, or what the commission would request in terms of following up the impact, because there's a lot of recommendations that will ultimately impact the allocation. I think trying to distill that in terms of specifically to exchange funds and the impact of the allocation amounts, I don't know if we'll come to that similar struggle of saying, this caused this, or this was related to this impact, because there's so many overlapping and interrelated issues that the working group is currently considering and offering recommendations.
So can you suggest, I'm not wedded to the language I said, I'm interested in understanding how this would work. And it is a change from what the current rule is. It might be a fine change. It might have some unintended consequences. So do you have a suggestion of something that would be more manageable? Than I try to thoughtfully think about, like, very general kind of like, help us understand if there's an impact kind of language. That seems like something in the commission's purview.
So I'm gonna ask Heidi to respond, and then
I just want to paint a picture for the only way I see being able to actually answer that question, Catherine, is to require every QLSP to provide for their application period, a detailed by county accounting of how they would have exchanged the funds, right? So it's basically, right now we just exchange, what they do in the application is they report how much they received and how much they spent, and then there's a reconciliation, right? So, but in order for us to actually meaningfully apply that information across the board and make a calculation on how did that money impact the actual allocation, we have to have that broken down by county. And that is not how, so we would be asking the applicants to not only report how much they gave and received, but then they'd have to break it out by county in order for us to factor that into the allocation model and get the impact organization by organization.
So they would tell you that by where they spent the money.
Well, but it's not in the application. That's not how it gets recorded. We get the total exchange funds by organizations, lump sum. And then there's a separate page that details the expenditures by county. It is not clear where the exchange funds show up in those counties. So we would have to ask organizations to do an additional, reporting to us by county those exchange funds. And so what I would, before we went down that, I would probably want to get some community feedback on whether or not they want to go down that path, because the community feedback we receive from the organization is exchange funds are so hard. We would gladly, everybody wanted to do away with it. It was like a party when we had our community, until it was like, oh, wait, there is an impact. There's a price we might have to pay for this. And so there was pause at that moment, but, sort of to go back and say, okay, hey, we're going to ask you to do this really burdensome additional step for data collection purposes only. I just want to caution, you're asking the orgs to do a really big lift, and then we would have to.
Yeah, I'm not really asking that they do.
Okay, Catherine, hang on. Okay, let's hear from Amin, and then I think we grasp what you're proposing, and we'll get to it. So, Amin.
Perfect.
Thank you, Patience. I've been following this whole discussion and I've been trying to figure out kind of where I fit in this and how I feel about it, because I think there's a lot to what Catherine's saying and the ripple effect and the impact. And the first thing that came when I read through the memo was, what about double counting? And on this point about kind of reporting, I'm not opposed to the idea. I think it may be helpful to kind of think of it in a broader context in terms of, you know, revisiting at some point the impact of some of the changes that we've made and whether they've been good just as a whole. To me, that something like this sounds to me, and from my understanding, it's a heavy lift to figure out how to do that in terms of making sure we have the right data, accurate data, and then figuring out how to calculate it in comparison to everything else. That's an exercise that's beyond what my brain can handle at this very moment. So figuring out how that works, you know, again, not opposed to it, but it seems like it's a heavy lift. But the second question, I think, is the bigger question, which is, what is the question that we want to answer? Is the question, and this is, I think, what we should talk about maybe now and resolve now as a group, which is the policy question, which is, if this has an impact whereby X happens, that's what we don't want to have be the case. And if Y happens, then that supports what we want to accomplish. To me, the X and the Y here is, in part, and I'm inviting others to sort of contribute, because the way I see it is, a big factor here is encouraging the money to be used in the most effective way. And if organizations determine that using it in the way of you know, in a sub-granting process is the way that they think the money can be used most effectively to achieve legal services to indigent communities, then I think it supports what our goal is. And if, you know, double counting is the problem, but at the same time we're getting the money down into services more effectively, then maybe that's a problem that we are okay with living with. But then, you know, on the other side of it, to me, we're starting to get into a realm, and maybe we do want to get into this realm, but I think this is a much bigger discussion of oversight over sub-granting that occurs by these organizations. And we do that in certain contexts. We invite that with respect to the discretionary grants that we give, and, you know, we encourage it. We encourage organizations to work with each other to have the services be provided. But it adds, in this sort of context, it seems like we're sort of inviting another layer of not just oversight, but sort of administration and kind of over, you know, another layer that maybe we're not equipped or interested or need to engage in at this stage. So I mean, that's sort of, I wish I had like an answer to all of this. I don't. But those are the things that are in my mind. And to me, it sounds to me like the working group worked through a lot of these issues, thought through a lot of these issues. I appreciate the time and effort that they did, and staff, certainly. And I'll leave it to patience, but yeah, I'll leave it there. Thank you.
I don't know what's being left to me exactly, but let me just ask this. It's my understanding, if I understand correctly, this rule 3.680, the rules committee is going to chew through the whole dang thing. And when we're done with our work, then it will go, then the rule as a whole, all the amendments to the rule will go out for public comment at that point. Because, and now I'm confused about who said this, but I thought it was a really good point, that there are potentially multiple, you may not be able to draw a causal connection between the change in the exchange funds treatment and the change in allocations in a county for small programs or whatever the concern is. There may not be you may not be able to draw that through line, because a bunch of other changes are happening also in rule 3.680. So I think what we will see over time, I just remember Heidi had this massive spreadsheet with, you know, this scenario, then this could happen, and this other scenario, something else could happen, and it was all extremely complex and dizzying. But I think we will begin to see, and LAC will tell us, and grantees will tell us. I mean, I think it's very important that grantees have not risen up in outrage at this concept. I mean, this is, we did not get feedback through LAC that this was problematic. And I think that's maybe even the most important, you know, in terms of consequences intended or otherwise, the anticipated consequences from this change, seems to me that the programs would be most alert to that and most likely to raise them emphatically if it was likely to be a problem. So at this point, I would like to call for the question, and I would like somebody to make a motion of some kind, whatever it is. Jason has suggested it could go back. Catherine has suggested that they're a friendly amendment, you know, but there's got to be a motion on the table, and then let's go forward.
Jason, do you want to take the public comment or?
Oh, I'm sorry, I forgot about the public comment. Thank you so much. And then Jason, you're up. Yes.
Kim, could you? Yes, thank you.
Allison.
Thank you very much. I want to thank all of you for all the attention you're giving to these issues, and would just urge the Rules Committee to hold off on approving the excluded expenditures language as is. So just following up on the conversation started at the top of the call, we're very concerned as a support center about the definition of required subgrants for many of the same reasons that were brought up when talking about exchanged funds. So we subgrant a substantial amount, more than half of our budget, and some of these we decide to subgrant in our discretion. We subgrant to legal aid organizations, which facilitates the provision of legal services in our state and access to justice for indigent Californians. We don't want to count those as part of our corporate expenditures. We would like those to be excluded expenditures. And so as was brought up earlier with the discussion about the exchanged funds, to do otherwise would disincentivize us and other support centers from regranting, because if we have to count it as part of our expenditures anyway, then that takes away the incentive to give it to legal aid organizations who may be able to use it for the provision of legal services. So I just want to raise that up, that same incentive issue plays out for the required subgrants language as is as well. And I really appreciate, again, the attention that you're giving to these issues.
So Allison, let me just be sure I understand. You're saying that your organization would prefer.
I'll clarify. Yeah. So our organization.
I'm sorry. Let me just ask. Let me formulate my question, then ask it. Your organization would prefer to be able to count the dollars you subgrant, as well as have the subgrantee count them, or that's what you're concerned about? You don't want to have that happen.
We don't want to count them. We want them to be excluded expenditures. So anything that we subgrant is excluded. So right now the language is required subgrants, and some of our subgrants are not per se required. They may be in our discretion, but that is one way that we facilitate access to legal services is by subgranting some of those funds. So in other words, if it could be subgrants that are excluded, not just required subgrants, we don't want to count that, those. We would like to pass them along and have the agency that is the subgrantee count them.
Patience, can I ask a question?
Yes.
Of Allison. So Allison, can I ask, right now, what do you do with your discretionary subgrants? How do you count them?
So under the current pass-through language, they are not included as our total corporate expenditures.
You treat them as pass-throughs.
We treat them as pass-throughs, that's right.
But this is money that you come in, it's not required for you to subgrant. You use your discretion to do so.
That's right. And under the current language, which I know we've spoken with many folks here, because it's about whether we have agency or control over that funding, and we do not, so we subgrant it, and those folks then perform the work. And so I think what we're worried about here is the language required, because that's stricter than the current language of what a pass-through is.
Can I ask something though? But like, is there a reason, do you, if you give it to people who are, to organizations who engage in qualified legal services, you don't want to count it as a qualified expenditure?
So we're a support center. So it would.
Okay. Sorry.
Yeah, so it really, the incentive structure that was talked about with the exchange funds plays out here as well. So we re-grant more than half of our, more than $10 million. And a lot of that is to organizations to provide legal services. But we as a support center, you know, we are looking for support center services. So we do not want to count that funds. We'd want them to be excluded.
Thank you.
Okay, so just, I want to make sure I'm understanding this, because I'm not sure that I am. So as a support center, if you are expending funds on a qualified legal service subgrant, you have to deduct them because they're not support center activities. Is that what you're saying?
That's exactly right. Yeah.
Okay.
That's exactly right. So to change the definition the way it is currently written would disincentivize us to pass along funds of provision of legal services, because we would have to count, we would not be able to exclude it.
Well, I get
for support center services. That's right.
Right. So if more than $10 million of your money's going out the door voluntarily for non-support center activities, I guess I think that does pull into question whether or not you meet the definition of a support center, wouldn't you? I mean.
So our primary purpose as an organization is to provide support center activities. That is what we provide trainings, we provide technical assistance. We also re-grant to other organizations. We don't provide any client services ourselves.
Right, but you're choosing to spend money for the direct provision of legal services by others as a support center.
So certainly not all of that. I'd say a lot of it is required subgranting, but to the extent that some of it is left up, we act as an administrator for many large pots of funds where it is very required by the funder to pass it along for the provision of legal services. So I understand under the current definition, those would be excluded. I'm talking about the smaller number of places where it is up to our discretion. And so just asking for that required subgrant language to be a little less restrictive.
Thanks. Does anybody else have questions of Allison? Okay, Jason, you had your hand up. I think Amin did have his hand up. Does either of you want to speak now?
Sure, I can go. I was going to move the motion as presented.
All right, is there a second?
I will second.
I will do roll call. Alakani?
Let's see. At this point, there's no more discussion, right? It's just voting.
Right.
Yes or no, or abstain, or what are the options?
Right.
Yes, no, or abstain.
I'd like to abstain.
Thank you.
Al-Saraf?
Yes.
Blakemore?
No.
Campbell? Connolly?
Yes.
Galkin?
Yes.
Zanville?
Yes.
Milrod?
Yes.
Okay. 5 yes, 1 no, 1 abstention. Motion passes.
Is there any other business that we need to address today? Jason, do you still have your hand up, or are you?
I just put it up really quick, and I realize this is other business, but I want to express my gratitude for everyone's thorough discussion and debate over this. It was a lot for us as a working group to grapple with, and I appreciate that everyone else is grappling with it too. It makes me feel like I'm not crazy and having a look grappling with it. So I appreciate this is really challenging for all of us. So I appreciate it. It continues to be challenging, and I want everyone to know that's meaningful to me. So thank you.
Thank you. Catherine.
At the next rules committee meeting, is it possible for the staff to come back with some ideas about how this commission can evaluate the impact, maybe not just of this rule? I understand the interconnectedness of it, but I would have voted for this rule if there were some willingness and not resistance to identifying strategies by which the commission can do what I think is an equally important obligation to understand the impact of this, and that we need to do that ourselves and get information from grantees, of course, but so I'm making that request.
Yes, we can certainly do that. And I actually have some thoughts, but I want to let me confer with Heidi and Crystal to see if I'm like so off the cuff, but we'll brainstorm some stuff and bring it back to certainly. And Patience, can I make also an announcement about the work plan? So as you can see this play out, you know, a lot of these working groups have met really tirelessly. I mean, Erica's been on Passthrough for like twice now, and it's been taking a couple years. So this is all to say that we had a really ambitious work plan this year. I was really hoping to tackle all of the fiscal issues this year. I had put actually Heidi on 2 working groups, are running parallel tracks. It's just 3, I'm sorry. It's too much. So if you all are okay, we're gonna go back and look at the work plan. We're gonna slow it down probably a lot on the fiscal side, just to rather slow it down and get all the information we need to be a bit more thoughtful than to try to rush it. I think I was being a bit too ambitious. So we'll just want to make that announcement, and then we'll go back to the working groups to make sure dates are comfortable, and then I'll integrate it into a new work plan, share it with Patience, get her sign off, and then I'll send it out to all of you.
Thank you all. I totally echo every single thing Jason just said about this conversation. Really appreciate it. Really appreciate the work groups and the staff's work on making a proposal and getting it to us. So thank you all. See you next time, May 8th, I think, right? Take care.
Thank you.
Bye-bye.